Civil law, the body of law governing disputes between private parties, individuals, businesses, or organizations, where the goal is not punishment, but compensation, resolution, or the enforcement of rights and obligations. Civil liability, the legal responsibility of a party in a civil case to compensate another for harm caused, distinct from criminal liability in that it results in monetary damages or court-ordered action rather than imprisonment. Tort, a civil wrong, other than a breach of contract, that causes harm or loss to another person, giving the injured party the right to sue for damages. The three main categories are intentional torts, negligence, and strict liability. Tortfeasor, the person or entity that commits a tort, meaning the party whose wrongful act or omission causes harm to another and who may be held liable for resulting damages in a civil lawsuit. Plaintiff's burden of proof. In civil cases, the plaintiff must prove their claims by a preponderance of the evidence, a significantly lower standard than the criminal standard of beyond a reasonable doubt. Preponderance of the evidence. The standard of proof in most civil cases, requiring the plaintiff to show that their version of events is more likely true than not, essentially that the scales of evidence tip even slightly in their favor, above 50%. Clear and convincing evidence. An intermediate standard of proof, higher than preponderance but lower than beyond a reasonable doubt, required in certain civil matters such as fraud, termination of parental rights, or civil commitment proceedings. Damages. The monetary compensation awarded to a prevailing party in a civil lawsuit to remedy the harm they suffered as a result of the defendant's wrongful conduct. Negligence. The failure to exercise the degree of care that a reasonably prudent person would use under the same or similar circumstances, resulting in unintended harm to another person who was owed a duty of care. Duty of care. The legal obligation requiring a person to act with reasonable care toward others who could foreseeably be harmed by their actions or omissions. The first element that must be established in any negligence claim. Breach of duty. The failure to meet the standard of care that a reasonably prudent person would have exercised under the same circumstances, constituting the second essential element of a negligence claim. Causation. The required link between the defendant's breach of duty and the plaintiff's injury, consisting of two components, actual cause and proximate cause, both of which must be established for a negligence claim to succeed. Actual cause. Also known as cause in fact, this is the direct causal link between the defendant's conduct and the plaintiff's injury, typically established through the but-for test, asking whether the injury would have occurred but for the defendant's actions. But-for test. The foundational test for actual causation in negligence, asking whether the plaintiff's injury would have occurred but for the defendant's negligeful conduct. If the answer is no, causation is established. Proximate cause. The legal limitation on liability requiring that the defendant's conduct be sufficiently connected to the plaintiff's injury. Not just a factual cause, but a foreseeable and direct enough cause that it is fair to hold the defendant responsible. Foreseeability. The legal principle that a defendant is only liable for consequences that a reasonably prudent person could have anticipated as a likely result of their conduct at the time they acted, serving as the key test for proximate cause. Harm. The actual injury, loss, or damage suffered by the plaintiff, physical, emotional, financial, or reputational, that forms the fourth essential element of a negligence claim. Without provable harm, there is no valid negligence case. Reasonable person standard. The objective legal benchmark used to evaluate whether a defendant's conduct was negligent, asking what a hypothetical reasonable person of ordinary prudence would have done under the same circumstances. Gross negligence. An extreme or aggravated form of negligence reflecting a conscious and voluntary disregard for the safety of others, going far beyond ordinary carelessness and sometimes used as the basis for punitive damages. Negligence per se. A legal doctrine establishing that a defendant's violation of a statute or regulation designed to protect a specific class of people constitutes negligence as a matter of law, without requiring further proof of unreasonable conduct. Contributory negligence. A traditional common law doctrine providing that if a plaintiff is found to have contributed in any way to their own injury through their own negligence, they are completely barred from recovering any damages from the defendant. Comparative negligence. The modern replacement for contributory negligence in most jurisdictions, apportioning fault between the parties so that the plaintiff's damages are reduced, but not necessarily eliminated, in proportion to their share of responsibility. Pure comparative negligence. A version of comparative negligence allowing a plaintiff to recover damages even if they are up to 99% at fault for their own injury, with their recovery simply reduced by their percentage of fault. Modified comparative negligence. The most widely used form of comparative negligence, barring a plaintiff from recovering any damages if their fault reaches or exceeds a threshold, typically either 50% or 51%, depending on the jurisdiction. Assumption of risk. A defense asserting that the plaintiff voluntarily and knowingly encountered a known danger associated with an activity, thereby relieving the defendant of liability for injuries arising from that inherent risk. Vicarious liability. The legal doctrine holding one party, typically an employer, responsible for the negligent or wrongful acts of another party, typically an employee, when those acts are committed within the scope of their relationship or employment. Respondeat superior. Latin for let the master answer. The specific doctrine of vicarious liability, imposing liability on an employer for torts committed by an employee acting within the scope of their employment duties. Intentional tort. A civil wrong in which the defendant acted with purpose or knowledge that their conduct would cause harm, as opposed to negligence where the harm was unintended. Intent to cause the specific injury is not always required, only intent to perform the act. Assault. In civil law, the intentional act of causing another person reasonable apprehension of imminent harmful or offensive contact, even without any physical touching actually occurring. Battery. The intentional and harmful or offensive physical contact with another person without their consent, forming one of the oldest and most fundamental intentional torts recognized in civil law. False imprisonment. The intentional and unlawful confinement or restraint of a person within a bounded area without their consent and without legal justification, regardless of the method used to accomplish the restraint. Intentional infliction of emotional distress, IIED. A tort requiring proof that the defendant engaged in extreme and outrageous conduct that intentionally or recklessly caused the plaintiff severe emotional distress, going well beyond mere insults or ordinary rudeness. Trespass to land. The intentional and unauthorized entry onto another person's land or property, regardless of whether any actual damage results, as the mere unpermitted entry is sufficient to establish liability. Trespass to chattels. The intentional interference with another person's personal property, short of complete destruction, that damages, diminishes the value of, or temporarily deprives the owner of their use of the property. Conversion. The intentional and serious interference with another person's personal property, so significant that it effectively deprives the owner of the property, justifying a court award equal to the full value of the item rather than merely the cost of repair. Defamation. The communication of a false statement of fact about a person to a third party that damages that person's reputation, divided into libel, written, and slander, spoken, with different rules applying to public figures versus private individuals. Libel. The written, printed, or otherwise permanently recorded form of defamation, generally considered more serious than slander because of its potential for wider dissemination and lasting harm. Slander. The spoken or transitory form of defamation, typically requiring the plaintiff to prove actual damages unless the false statement falls into a category considered so harmful that damages are presumed. Invasion of privacy. A category of intentional torts protecting individuals from 4 types of interference with personal privacy: intrusion upon seclusion, appropriation of name or likeness, public disclosure of private facts, and false light. Malicious prosecution. A tort claim arising when a person initiates or continues a criminal or civil proceeding against another without probable cause, with malicious intent, and the proceeding ultimately terminates in favor of the accused. Fraud. An intentional misrepresentation of a material fact made with knowledge of its falsity and with intent to induce another person to rely on it, causing actual damage to that person as a result of their reasonable reliance. Misrepresentation. A false statement of fact made by one party to another, which may be intentional, negligent, or innocent, and which induces the other party to enter into a contract or take action to their detriment. Strict liability. A legal doctrine holding a defendant liable for harm caused by their conduct regardless of whether they acted with intent or negligence, applied in situations where the activity or product is considered so inherently dangerous that fault is irrelevant. Abnormally dangerous activity. An activity that creates a high risk of serious harm even when conducted with the utmost care, subjecting the person who engages in it to strict liability for any resulting injuries, regardless of precautions taken. Products liability. The area of law holding manufacturers, distributors, and sellers strictly liable for injuries caused by defective products placed into the stream of commerce, without requiring the plaintiff to prove negligence. Manufacturing defect. A product flaw occurring during the production process that causes an individual unit to deviate from its intended design, making that specific product unreasonably dangerous, even though the design itself was sound. Design defect. A flaw inherent in the entire product line arising from a fundamental problem with how the product was designed, making every unit of that product unreasonably dangerous, regardless of how carefully it was manufactured. Failure to warn. A type of products liability claim asserting that the manufacturer failed to provide adequate instructions or warnings about risks associated with using the product that were known or knowable at the time of distribution. Breach of warranty. A civil claim arising when a seller fails to fulfill a promise, either express or implied, about the quality, fitness, or characteristics of a product or service sold to the buyer. Contract. A legally enforceable agreement between 2 or more parties, creating mutual obligations, requiring an offer, acceptance, consideration, capacity, and legality to be valid and binding under the law. Offer. A definite proposal made by one party, the offerer, to another party, the offeree, expressing a willingness to enter into a contract on specific terms, which if accepted creates a binding agreement. Acceptance. The offeree's unequivocal agreement to the exact terms of the offer, which when communicated to the offerer creates a binding contract. Any modification of the terms constitutes a counteroffer rather than an acceptance. Consideration. The exchange of something of legal value between the contracting parties, money, goods, services, or a promise to act or refrain from acting, that serves as the price paid for the other party's promise and is required for a contract to be enforceable. Capacity. The legal ability of a party to enter into a binding contract, requiring that they be of legal age and of sound mind. Contracts entered into by minors or mentally incompetent persons may be voidable. Breach of contract. The failure of one party to fulfill their obligations under a valid contract without legal justification, entitling the non-breaching party to seek legal remedies including damages or specific performance. Material breach. A significant failure to perform a contractual obligation that goes to the heart of the agreement, substantially depriving the non-breaching party of the benefit they bargained for and justifying termination of the contract. Anticipatory breach. A breach that occurs before the performance date when one party clearly communicates, through words or actions, that they will not be fulfilling their contractual obligations, allowing the other party to treat the contract as broken immediately. Specific performance. An equitable remedy ordering the breaching party to fulfill their contractual obligations as promised, typically awarded when the subject matter of the contract is unique and monetary damages would be an inadequate remedy. Rescission. The cancellation or unwinding of a contract, returning both parties to the positions they occupied before the contract was formed, available as a remedy for fraud, misrepresentation, mutual mistake, or material breach. Restitution. A remedy requiring the defendant to return or compensate for any benefit they received from the plaintiff to prevent unjust enrichment, often used when a contract is voided or rescinded. Indemnification. A contractual obligation by which one party agrees to compensate another party for specified losses, liabilities, or expenses arising from particular events or claims, commonly found in commercial and construction contracts. Liquidated damages. A pre-agreed sum specified in a contract that the parties agree in advance will serve as compensation in the event of a breach, enforceable when the amount is a reasonable estimate of anticipated damages rather than a penalty. Force majeure. A contractual provision excusing a party from performing their obligations when extraordinary circumstances beyond their control, such as natural disasters, wars, or pandemics, make performance impossible or impractical. Statute of frauds. A legal requirement that certain types of contracts, including those for the sale of real estate, contracts lasting more than 1 year, and agreements for the sale of goods above a specified value, must be in writing to be enforceable. Compensatory damages. Monetary awards intended to make the plaintiff whole by compensating them for the actual losses they suffered, divided into special damages for quantifiable economic losses and general damages for non-economic harm. Special damages. Also called economic damages, these are quantifiable financial losses the plaintiff suffered as a direct result of the defendant's conduct, including medical expenses, lost wages, property damage, and future earning capacity. General damages, also called non-economic damages, these compensate for intangible harms that are real but difficult to quantify, including pain and suffering, emotional distress, loss of consortium, and diminished quality of life. Punitive damages. Damages awarded above and beyond compensation for actual losses, intended to punish the defendant for particularly egregious, malicious, or reckless conduct and to deter similar behavior in the future. Nominal damages. A small symbolic monetary award, often just $1, granted when the plaintiff has proven a legal wrong but has suffered no measurable actual harm, recognizing the violation of a right without significant injury. Consequential damages. Damages covering losses that were not directly caused by the breach or wrong itself, but are a foreseeable downstream consequence of it, recoverable only if the defendant knew or should have known these losses could result. Mitigation of damages. The legal duty of the injured party to take reasonable steps to minimize their losses after being harmed, preventing them from recovering damages for losses they could have reasonably avoided through their own efforts. Injunction. A court order compelling a party to do something or, more commonly, to stop doing something, available as an equitable remedy when monetary damages would be inadequate to fully address the plaintiff's harm. Subrogation. The legal right of one party, typically an insurer, who has compensated another for a loss to step into that party's shoes and pursue a legal claim against the third party originally responsible for causing the loss.